William Market in North Carolina. How may I help you?
Howdy there. I'd like you to sell my North Carolina apples here.
Sure, USDA labels. Sure. I'll accept these and I'll have the manager get back to you.
Thank you, ma'am.
You're welcome. Market.
Hey, how's it going? Can you sell my apples from Washington?
Sir, I mean, the statute in effect now, all importers of apples need the USDA label.
What? My
And
apples
yours
are from
don't-
Washington. It's the best apples.
Yeah, but you don't have the USDA label, so I'm sorry, I can't accept your apples.
I can't
So
sell.
please, I would like you to leave my market right now.
How about them apples?
Working on a petition, and I noticed that your apples were rejected by this market.
Yeah, it's crazy. I just brought my apples from Washington, and they rejected me. I'm not
Huh.
used to that. They're the best apples.
How long have you been a farmer?
You know, for a while, I used to ride my bike a lot out at my dad's farm, and we'd go to Starbucks. And I've been a farmer for about 20 years now. It's the Starbucks closed down, so I just started growing apples.
And your main source of income are these apples, huh?
Yeah, I gotta sell my apples.
North Carolina even enacted this statute in the first place. North Carolina's position, and also argues that in order to protect their citizens from the treacherous effects of apple grades, there must be a uniform grade representation on all crates and apples within their state. So this way, consumers would know whether they're going to have a safe apple or a dangerous apple. On the other hand, we have the Washington Apple Commission, which applies its own grade to their own apple crates and their own apples themselves. Washington's position is that their grades are more widely known, and they have a commission applies its own level of grades to their apple crates and apples as well. They're arguing, and their position is, that their grades are more widely known throughout the nation, and on top of that, their grades have harsher standards, which makes it safer for the consumer to eat an apple with a Washington label instead of the North Carolina label. So what's the big deal? Why is the Washington State Apple Advertising Commission even angry in the first place? Well, they kind of feel that the North Carolina statute is discriminating against them, and they're arguing in three basic positions. So, unlike their North Carolina counterparts, Washington's now going to have to remake all of their crates. All their crates become pre-made, and when they put their apples inside of them, they have the grade corresponding to which kind of apple you're going to get. So in order to abide by this statute, they're going to now have to redo all of their marketing campaign, all of their crates, and this not only puts them at a severe economic disadvantage, but they were already at a disadvantage before, given the distance between Washington and North Carolina itself.
Is that too much of a burden?
That is too much of a burden. But the court considers two other factors. So, what else is Washington being discriminated? Washington statute, or the North Carolina statute is essentially stripping away the Washington apple industries of their competitive and economic advantages. The record has already shown that Washington apple grade system has gained nationwide attention. As you can see from all these apple affidavits that were submitted by all of these consumers as well as sellers, they all prefer that the Washington apple grade is on their apples and not some North Carolina one. So, as we turn to now, the final third factor that the court indicates is that the statute insidiously operates to an advantage of the local producers. with the local producers having only to abide by their own apple grade standard instead of a recognized one or some sort of uniform version, they distinctly have now an advantage. Not only are they within the area that they're able to sell, they don't have to change their marketing material, and they only have to abide by one certain standard. Therefore, the court concludes that, given this statute, would be discriminatory on Washington.
Hello, Conlaw One. I'm going to be discussing the organizational aspect of the Hunt v. Washington state case, and I'm going to be presenting the argument that North Carolina tried to get by in court and ultimately failed. So North Carolina officials were arguing that Washington Commission had no standing to prosecute this action, either in its own right or on behalf of that state's apple industry, which it purported to represent. North Carolina argued that the commission lacked the personal stake in the outcome necessary for this litigation. It argued that the commission is a state agency not itself engaged in the production and sale of Washington apples and their shipment into North Carolina. In fact, it argued that its only activities within North Carolina were the promotion of the Washington apples in that market through advertising. They contended that the challenge statute had no impact on that activity meaning the promotion of Washington apples. So North Carolina was arguing that the statute imposed no restrictions on advertisements, and that the Washington Commission's only purpose within the market was to advertise the Washington state apples. And because the restrictions were only placed on parties who engaged in the apple trade, the commission was said to be free to carry on the same activities that it engaged in prior to the regulatory program. So I know at this point you're probably wondering, well, what's the core of the problem here? Well, the core of the problem is that North Carolina, therefore, was arguing that the commission suffered no injury, economic or otherwise, from the statute's operation. And as a result, it cannot make out a case in controversy between itself and appellants needed to establish, in the constitutional sense, organizational standing. Constitutional sense? Why, yes. I'm so glad that you questioned the way that I phrased that. So what I mean by that is, in order for a Supreme Court to hear a case, there must exist a case in controversy. And one of the requirements for a case in controversy to exist at all stages of the litigation is standing. Understanding, or a subcomponent of standing, is organizational standing. And North Carolina was essentially asserting that the commission lacked standing. Therefore, there was no case in controversy, and the case should be thrown out. That the commission could not rely on the injuries which the statute allegedly inflicted individually or collectively on Washington apple growers and dealers in order to confer standing on itself. They argued that if anybody was injured, it was the growers and the dealers, and they had no disability which prevented them from coming forth to protect their own rights. In any event, appellants contended that the commission was not the proper representative of the industry's interest. So far, we looked at the claim that North Carolina presented about the commission lacking standing. North Carolina asserted that the commission was not an organization in the traditional sense because it was a state agency and it did not suffer an injury directly, and that if anyone suffered an injury, it was the growers and the dealers who were in fact not handicapped and should be the parties bringing this matter before the court for adjudication. Let's take a look at what the court had to say about that. So the court on review said that the only issue here was whether the commission's status as a state agency rather than a traditional voluntary membership organization precluded it from asserting the claims of the Washington apple growers and dealers who formed its organization. The court said we think not. It did not. The fact that the commission was a state agency and not an organization in the traditional sense, the court did not think that that would preclude it from bringing this claim. It said that the commission, while admittedly a state agency for all practical purposes, performed the same functions as a traditional trade association representing the Washington apple industry. Moreover, the court held that while the apple growers and dealers were not members of the commission in a traditional trade association sense, they still perform the duties that members within a traditional organization would. For instance, they alone elected the members of the commission, they alone served on the commission, they alone financed its activities, including the cost of this lawsuit, through assessments levied upon them. The court also stated that membership in a union is equivalent and often required. Likewise, membership in a bar association, which may also be an agency of the state, is often a prerequisite into the practice of law. Yet in neither instance would it be reasonable to suggest that such an organization lacks standing to assert the claims of its constituents. Finally, the court reasoned that the commission had standing to assert the rights of the individual growers and dealers, and has long recognized that an organization may have standing to assert the claims of its members even where it has suffered no injury from the challenge activity. So, moving back to the beginning of this presentation, I discussed that in order for the Supreme Court to hear a case, there must exist at all stages of the litigation a case in controversy. And one of the requirements for a case in controversy to exist was standing. This case in particular dealt with organizational standing because the commission was asserting its right as an organization. The commission was asserting its right as an organization to represent the members of its organization. The rule for organizational standing is organizations always have standing to sue if the injury is to the organization itself. Organizations may also sue on behalf of its members if at least one individual member has standing to sue, and injury is related to the organization's purpose or what it's about, and neither claim nor relief requested requires participation of an individual member alone. Thank you, Con Law 1, for listening to me talk extensively about organizational standing. I hope that I covered everything, and now you're going to enjoy our next clip.
Washington apples. They're as good as you've heard.